Welcome to the Provincial Training on Workplace Violence and Harassment. In today's training, we will cover the following topics. 1. Bill 168. 2. What is workplace harassment? 3. What is workplace violence? 4. Our responsibilities. And lastly, what to do if you experience workplace harassment or violence. The objectives for today's training are 1. To learn what constitutes and what does not constitute workplace harassment. 2. To understand the continuum of unwanted behaviors. 3. To learn what workplace violence is, including domestic violence and how it can spill into the workplace. 4. To understand who is affected by workplace violence and the risk factors. 5. To understand the responsibilities of employers, supervisors, and yourself in protecting and managing workplace violence and harassment. 6. To learn what to do if you experience workplace violence and/or harassment. This training is important because in 2017, a study conducted on workplace violence and harassment in Ontario revealed that 1. 60% of respondents have experienced harassment in the workplace. 2. 30% have experienced sexual harassment. 3. 21% have experienced violence. And 3% have experienced sexual violence. Additionally, most respondents who experienced harassment, sexual harassment, or violence in the past 2 years indicated that they have experienced it more than once, so it is a significant problem in Ontario. Module 1. Bill 168. Bill 168 amended the Occupational Health and Safety Act to require employers to develop and implement policies and programs to prevent and address workplace violence and harassment. Now, under the Ontario Occupational Health and Safety Act, employers are required to assess risks of workplace violence and harassment, develop corresponding policies and procedures for investigating and handling complaints and incidents, and give employees proper information about policies and programs. That concludes Module 1. Module 2. What is workplace harassment? The Occupational Health and Safety Act defines workplace harassment as engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. It involves words or actions that are offensive, embarrassing, humiliating, demeaning, discriminating, isolates, or intimidating. Workplace harassment also includes workplace sexual harassment and psychological harassment. It's important to note that generally, more than one act is needed in order to constitute harassment. Harassment is the repetition of a series of incidents. However, one single incident can be considered harassment when it is demonstrated that it is severe and has a significant and lasting impact on the individual. The following scenarios help demonstrate what is considered harassment and what may not be considered harassment. First, let's look at a scenario that would not be considered harassment. Imagine that the workplace emergency response team are out on an exercise. Once completed, and after working hours, the team decides to go to the local pub. One of the team members, Louise, a new employee, and Mike exchanged on a political topic. Both shared different views of the issue. Next, let's look at a scenario that may be considered harassment. When it is time to leave, Mike, who had too much to drink, hits on Louise, the designated driver, and then tells her where to go by using profane language. Louise is upset by the incident and approaches her union representative the following morning. Mike, Louise, and the union representative meet. Mike acknowledges his inappropriate behavior and offers an apology to Louise. Louise accepts the apology. And lastly, let's look at a scenario that would be considered harassment. Mike returns to the workplace and speaks to his colleagues about Louise's reaction and refers to her as a crybaby and tries to convince them that she does not belong on the emergency response team. He deliberately ignores her by not answering her questions and winks at his colleagues whenever she speaks in a meeting. Louise had accepted Mike's apology and believed that the incident had been resolved informally. She now feels that this incident has crept into the workplace and has a detrimental impact on her and on her relationships with Mike and her other colleagues. Other examples of workplace harassment include making remarks, jokes, or innuendos that demean, ridicule, intimidate, or offend. Displaying or circulating offensive pictures or materials in print or electronic form. Bullying, for example, spreading malicious rumors, excluding or isolating someone socially. Repeated offensive or intimidating phone calls or emails. And workplace sexual harassment. Importantly, conduct that is a part of a manager's normal work function is not considered harassment. For example, changes in work assignments, scheduling, or workplace inspections. Job assessment and evaluation. Disciplinary action. Additionally, differences of opinion or minor disagreements among coworkers is not workplace harassment. Now, let's explore what is considered workplace sexual harassment. The Occupational Health and Safety Act defines workplace sexual harassment as engaging in vexatious comment or conduct against a worker in a workplace because of someone's sex, sexual orientation, gender identity, or gender expression. Additionally, it defines it as making a sexual solicitation or advance where the person making it is in a position to confer, grant, or deny a benefit or advancement to the worker, and the person knows or ought reasonably to know that the comment or conduct is unwelcome. Examples of sexual harassment in the workplace include asking questions, talking, or writing about sexual activities, rough or vulgar humor or language related to sexuality, sexual orientation, or gender, leering or inappropriate staring, invading personal space, unnecessary physical contact, including inappropriate touching, making gender-related comments about someone's physical characteristics, mannerisms, or conformity to sex role stereotypes. It's important to note that inappropriate and unacceptable workplace behaviors can occur on a continuum ranging from offensive remarks to violence. As such, workplace harassment may escalate over time. When harassment, including sexual harassment, involves threats, attempts, or acts of physical force, it is considered workplace violence under the Act. It is important for employers to recognize these behaviors and to deal with them promptly. Taking action can prevent harassment from escalating in the workplace and possibly resulting in physical violence by either the harasser or the targeted worker. That concludes Module 2. Module 3. What is workplace violence? The Occupational Health and Safety Act defines workplace violence as the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker, or attempting to exercise physical force against a worker in a workplace that could cause physical injury to the worker, and or a statement or behavior that a worker could reasonably interpret as a threat to exercise physical force against the worker in a workplace that could cause physical injury to the worker. Some examples of workplace violence include verbally threatening to attack a worker, leaving threatening notes at or sending threatening emails to a workplace, shaking a fist in a worker's face, wielding a weapon at work, hitting or trying to hit a worker, throwing an object at a worker, sexual violence against a worker, and kicking an object the worker is standing on, such as a ladder. It's important to note that the definition of workplace violence is very broad. The list of previous examples was not an exhaustive list of examples of workplace violence. There are many more examples that could include acts that would constitute offenses under Canada's Criminal Code. Now, let's better understand what is considered workplace violence by answering two common questions. What if a worker is accidentally hurt? Is this workplace violence? Accidental situations, such as a worker tripping over an object and pushing a coworker as a result, are not meant to be included. Does the person need to intend to hurt the worker? For workplace violence to occur, a person must apply, attempt to apply, or threaten to apply physical force against a worker. However, he or she does not need to have the capacity to appreciate that these actions could cause physical harm. For example, a person may have a medical condition that causes them to act out physically in response to a stimulus in their environment. This would still be considered workplace violence. This training is important because violence can affect all people in all jobs, especially for employees that handle cash, protect or secure valuables, transport people and goods, work in a mobile workplace, such as a vehicle, have public or community contact, work with unstable or volatile people, work alone or with just a few people, and work late nights or very early mornings. To prevent problematic behavior, before acting you should ask yourself the following questions. Would I participate in this behavior in front of my parents, spouse, or child? Would I engage in this behavior with a coworker of either sex? Would I make these remarks to a coworker verbally, by email, text, or other written communication? Would I like to have my behavior shared on social media? No. Answer to one or more of these questions may indicate that another employee may find your action or communication offensive and inconsistent with acceptable business behavior. Impact, not intent, is key. Domestic violence can spill over into the workplace, making it workplace violence. Although it is not required in the OHSA, workers should report to their employer/supervisor if they fear domestic violence may enter the workplace. Employers must take every reasonable precaution for the protection of the worker when they are aware, or ought reasonably to be aware, that domestic violence may occur in the workplace and that it would likely expose a worker to physical injury, including the targeted worker and/or coworkers. That concludes Module 3. Module 4. Our responsibilities. Let's start with employers' responsibilities. First, we'll look at employers' responsibilities under workplace violence. Employers must prepare a policy on workplace violence. This includes addressing violence from all possible sources and outlining the roles and responsibilities of the workplace parties in supporting the policy and program. Additionally, they must assess the risks of workplace violence. This should include assessing the risk of workplace violence that may arise from the nature of the workplace, type of work, or conditions of work, and then advising the Joint Health and Safety Committee of the assessment results. Lastly, employers must develop and maintain a program to implement the workplace violence policy. This includes developing measures and procedures to control the risks identified in the assessment as likely to expose a worker to physical injury, as well as providing instructions on how to report incidents of workplace violence and how to summon immediate assistance when workplace violence occurs or is likely to occur. And lastly, outlining how the employer will investigate and deal with incidents or complaints of workplace violence. The risks of workplace violence should be reassessed as often as is necessary to protect workers from workplace violence. For example, a reassessment should be undertaken if the workplace moves or the existing workplace is renovated or reconfigured. There are significant changes in the type of work. For example, more expensive items are being sold. There are significant changes in the conditions of work, for example, closing at a later hour. There is new information on the risks of workplace violence. Or, a violent incident indicates a risk related to the nature of the workplace, type of work, or conditions of work was not identified during an earlier assessment. In general, it is recommended the employer review the assessment, at least annually. Additionally, under the OHSA, the employer must maintain the workplace violence program. It is recommended the program be reviewed, at least annually. A review or revision of a workplace violence program should be undertaken if a reassessment of risks indicates revisions are needed. Workers, or the Joint Health and Safety Committee or Health and Safety Representative, indicate measures or procedures are not adequate or are not used. A violent incident shows that measures or procedures are not adequate, or the workplace's response to a violent incident or complaint shows the reporting or investigation procedures need to be revised. Notices. When an incident of workplace violence occurs, the employer should first notify police or emergency responders for immediate assistance. An employer must immediately notify, by direct means, a Ministry of Labor, Training and Skills Development inspector, the workplace's Joint Health and Safety Committee. Additionally, within 48 hours notify, in writing, a director of the Ministry of Labor, Training and Skills Development, giving the circumstances of the occurrence and any information that may be prescribed. Importantly, if there is an incident of workplace violence and a worker is disabled or requires medical attention, the employer must notify the Joint Health and Safety Committee within 4 days of the incident. This notice must be in writing and must contain any prescribed information. If required by an inspector, this notice must also be given to a director of the Ministry of Labor, Training and Skills Development. It should be noted that notices are not required for incidents of harassment. Now, let's look at employers' responsibilities under workplace harassment. First, employers must prepare a policy on workplace harassment, which includes considering workplace harassment from all sources and outlining the roles and responsibilities of the workplace parties in supporting the policy and program. Secondly, they must develop and maintain a program to implement the workplace harassment policy. This includes developing measures and procedures for workers to report incidents of workplace harassment to the employer or supervisor, including how to report to a person other than the employer or supervisor, if the employer or supervisor is the alleged harasser. Additionally, it should outline how incidents and complaints of workplace harassment will be investigated and dealt with. How information obtained about an incident or complaint of workplace harassment, including identifying information about individuals involved, will not be disclosed unless the disclosure is necessary for the purposes of investigating the incident or complaint, or for taking corrective action, or is otherwise required by law. And lastly, how the worker who alleged harassment and the alleged harasser, if he or she works for the employer, will be informed of the results of the investigation and of any corrective action. In order to protect a worker from workplace harassment, an employer is required to review the workplace harassment program as often as necessary, but at least annually. This review should focus on whether the measures and procedures are current and if there are any deficiencies or gaps that need to be addressed. The program may or may not be revised as a result of the review. The requirement to review the program as often as necessary could be triggered if within 12 months of the latest review, an incident, complaint, or investigation revealed deficiencies or gaps in the measures and procedures set out in the program, or measures and procedures that were not followed in a particular harassment case. When complaints or incidents occur, employers must investigate. Importantly, an employer should deal with workplace harassment, whether someone has formally made a complaint or the employer is otherwise aware of incidents. Additionally, during investigations, employers should take appropriate interim measures, such as temporary reassignments or shift changes, to protect workers and witnesses. Importantly, the worker who complained about workplace harassment should be kept informed about the status of the investigation, as should the alleged harasser if he or she also works for the employer. Remember, the Act prohibits employers from penalizing workers in reprisal for obeying the law or exercising their rights, which would include reporting an incident of workplace harassment. Investigations might look like this. First, a review of details of the incident or complaint, including any relevant documents. Then, an interviews with the worker alleging harassment, and interviews with the alleged harasser. Separate interviews with relevant witnesses. Next, an examination of relevant evidence that pertains to the investigation, such as emails, notes, photographs, or videos. Then, a decision about whether a complaint or incident is workplace harassment. And lastly, a preparation of a report summarizing the incident or complaint, the steps taken during the investigation, the evidence gathered, and findings. Results of an investigation. Employers must ensure that the worker who is allegedly harassed is informed in writing about the results of a workplace harassment investigation and of any corrective action that has been or that will be taken as a result of the investigation. This information must also be provided to an alleged harasser who works for the employer. As a result of incidents or complaints, corrective actions are actions taken to try to prevent a reoccurrence of workplace harassment. where the harassment arises from customers, clients, patients, or the public towards a worker. The employer could deal with the incident by modifying its service. For example, using the telephone or email as the primary means of contact, or even, in some cases, a refusal of service depending on the circumstances. On the other hand, where the investigation finds that harassment arises from a worker, supervisor, or other person associated with the workplace, there could be individual corrective action taken. For example, apologies, education, counseling, shift changes, reprimands, suspension, job transfer, or termination depending on the employer's policy and the nature or severity of the behavior. Now, let's look at workers' responsibilities. All employees should be aware of the workplace violence and harassment policy and program. Under workplace violence, workers must 1. Know how to summon immediate assistance. 2. Know how to report incidents of workplace violence to the employer or supervisor. 3. Know how the employer will investigate and deal with incidents, threats, or complaints. And lastly, know, understand, and be able to carry out the measures and procedures that are in place to protect them from workplace violence. Under workplace harassment, workers must 1. Know how to report incidents of workplace harassment to the employer or supervisor. 2. Know how to report incidents of workplace harassment where the employer or supervisor is the alleged harasser. 3. Know how the employer will investigate and deal with incidents or complaints of workplace harassment. 4. Know how information about an incident or complaint of workplace harassment will be kept confidential. And lastly, know that the results of an investigation and any corrective actions will be provided to the worker who alleged harassment and to the alleged harasser. Lastly, supervisor responsibilities include ensuring employees' behavior is consistent with policies, leading by example, maintaining leadership credibility, protecting against personal liability, protecting company reputation, knowing the procedures for reporting, investigating, and documenting incidents, and knowing how to respond appropriately to disclosures of harassment. That concludes Module 4. Please proceed. Module 5. What to do if you experience workplace violence or harassment. As you may recall from your training on OHSA or occupational health and safety, workers have the right to refuse work if they have reason to believe they may be endangered by workplace violence. However, work cannot be refused on the grounds of workplace harassment. Additionally, you may recall the continuum of unwanted behaviors, which explains how workplace harassment and violence can occur as a one-time incident or a continuum of unwanted behaviors in the workplace, escalating from offensive remarks to violence. That's why it is important to address unwanted behavior early to minimize potential for harassment to lead to violence. If you do experience violence or harassment, the following steps should be taken. 1. If threats or violence occur at your workplace, always contact police first in emergency situations. 2. Notify your supervisor, employer, or person identified in your workplace's harassment program of the incident, including what was said or done, who said or did it, and the names of any witnesses. If an employer is not complying with the workplace violence and workplace harassment requirements in the OHSA, workers can call the ministry's province-wide health and safety contact center. Additionally, a worker may also seek resolution of a workplace harassment incident or complaint outside of the employer's internal investigation procedure. For example, a worker may contact the Human Rights Legal Support Center for help or the Human Rights Tribunal of Ontario directly to file an application to have their matter heard if the alleged harassment is based on one of the grounds prohibited under Ontario's Human Rights Code. This concludes the training on workplace violence and harassment. After completing this training, you should know what constitutes workplace harassment, how unwanted behavior can escalate quickly, what constitutes workplace violence, how domestic violence can spill into the workplace, risk factors for workplace violence, the responsibilities of employers, supervisors, and yourself in protecting and managing workplace violence and harassment, and lastly, what to do if you experience workplace violence and/or harassment.